You're listening to the Valley Current.
We'd like to do an IP course. We want to do an IP course starting this week. Professor Risch is going to start formally on Friday at 1 o'clock. I'd like to start really on Wednesday with a slight overview today, but the overview today is in many ways on something that I sent to all of you about what's not IP. Because I think the best way to understand IP is to almost start with what's not intellectual property, that is, what's public domain. And we're right now on exactly that point, which is a generic word is in the public domain. It gets to be used freely. That is, a generic word like cola for a beverage means Pepsi Cola, Coca-Cola, Royal Crown Cola. There's probably a million different colas. They all get to use the word cola. They all can still have a brand, but it has to add other words. So Dropbox is saying that they have become famous, and because they're famous, you can't use drop. It's almost like Facebook saying, we're famous, so you can't use face. So Apple, you can't use FaceTime because that has the word face in it. You can't do that. I mean, that's a computer-based product. We own Facebook. Facebook is famous. You can't use
You can't
FaceTime.
say ebook. You can't say ebook because it's got book in it.
Well, book, actually, they have taken some wacky views about book as well. Facebook's done it too. So there's this whole area. I tell you, the client is just so pissed. I mean, maybe rightfully so. Not at me, but, he's a sole practitioner, a very typical sole practitioner. He's like, I can't believe this. I paid a bunch of money for the domain name. I went to LegalZoom. LegalZoom filed, the paperwork for the trademark. And then I get a bunch of letters back. And of course, he goes back to LegalZoom and says, I got all these letters from this guy in Palo Alto. What do they say? Hire a lawyer in Palo Alto. We're not lawyers. LegalZoom is a typing service. We don't give legal advice. You have to hire a lawyer. They gave him the wrong advice. You have to hire a lawyer in California. It's not actually a California case. The case is filed in
the trademark office.
Right. So it's actually technically a federal case in the sense it's an administrative law case. It's not yet a federal district court case. And it's an administrative judge, in fact, three administrative judges will decide on a written record, no oral advocacy. Maybe there might be one oral argument after everything is done, but no in-person, no witnesses, all on a written record get submitted two questions. One, I'll put them in reverse order. One, whether or not this mark is famous, Dropbox is famous, and therefore even dilution is subject to some type of relief in the trademark office. Now, think about that, because there's something like 900 different drop registered marks out there for different things, even beyond the computer industry, like what we just saw for drop.com. I'm not showing it because I've got a bad internet connection, and if I show drop.com, it'll probably blow up my audio. But generally speaking, we're dealing with a very aggressive litigant, Dropbox, who essentially is pushing their weight around. So, first question, what's the reaction to people? Do you think Dropbox is famous? And does it conjure up that anyone that uses Drop is trading on them and diluting the mark? Like, I could see them saying it's famous as to somebody that comes up with something like, drop crate, or, drop trailer, or drop truck or something, but, something that's you drop. I mean, Elizabeth's remark is just because something's well known doesn't really mean it's famous, right? Because you really have to have, like, everyone knows Kodak, right? Everyone knows Coca-Cola. right? Everyone knows Xerox probably, although maybe that's even generic. I mean, what's the reaction, Kim? That was the question.
Yeah, I think it's a ridiculous argument, actually. I mean, I don't know how they think they're going to get that past the trademark examiner.
No, their view of life is we have two arguments, we have two theories. See, because the client said to me, if it's so frivolous, wouldn't we score points by just like moving to dismiss? Because in the trademark office, it's like the federal district court. They almost follow the same set of rules of civil procedure, except they're all numbered differently. So think about, Rule 1 through Rule 98, whatever the total federal rules are these days. There's at least, 70 or 80. Maybe there's even 90. Someone could look that up and see how far, what's the last federal rule of civil procedure. It starts with Federal Rule 1 and then jumps forward to Rule 78 or 79. Maybe it's even more than that. 68, of course, is offers and compromise. They should put that in as Rule 2 in my book if I were reorganizing it. But there's essentially an analogous set of trademark trial and appeal procedural rules. And you do the litigation almost like it's a trademark case, except the sole remedy is whether or not the registration is allowed. So if the registration is allowed, that is, if drop is allowed, so it goes up, Ryan's saying it goes up to Rule 86. I'm surprised that they haven't hit 100. They could easily add 14 more rules. But if you think about it, if you go up to, if you think about like if the registration is allowed, that opens the dam for everyone to prevent them from becoming famous. Because Drop is there, then WeDrop. There actually is a competitor called WeDrop.com that does storage as well. I sent it to this guy, and the guy's like, "Yeah, we're going to sue you first and deal with them later. Like we're picking our poison here." So they make two arguments. Argument one is what I just said, famous. Argument two, which is really where the crux of the case is it likely to cause confusion for there to be both a drop box and a drop? That is, should the mark not be registered because Dropbox is a strong mark and there's going to be likely to confusion because the area of drop is almost identical, not perfectly identical, but almost identical drop? Is there going to be some belief that there must be a license agreement or some sort of sponsorship or some sort of affiliation? So this is a case where you could argue, is there intellectual property here in the word drop? Remember, drop is not the trademark that either side is actually arguing about. They're arguing about Dropbox versus drop. I almost said U-Box. It's funny. It should be like if it was U Dropbox, I think there would be a problem, right? That would be a problem. Right. That's exact use of the mark, right? So they he couldn't use U-Box because Box would complain. So he's gone with drop. He paid for it. But of course, paying for a domain name doesn't, and this is where clients, LegalZoom is, generates so much, behavior in clients. The client that buying the domain name gave him trademark rights. Are you with me? This is the way business people think. Paid for this. Therefore, it's mine. It's mine. How? And by the way, then I went to LegalZoom that formed my LLC. That's not a problem. And they formed my LLC with that trade name in Delaware, drop. So I've got the trade name rights, at least under state law in Delaware, right? And there was no conflict there. No one stopped me there. And then they said, typical selling by non-lawyers. By the way, everyone should think about this because it's creating a bit of a commodity practice in certain areas like this. Dropbox, LegalZoom said, yeah, we should file a trademark registration now because you've got the name, you've got the domain name, we should register it. Probably good advice. They filed the registration. what happens?
Oh, I didn't even know they did that.
Yeah, they do a ton of
I
stuff.
thought you had to tell them what you wanted to do.
No, they've got all these robots that are running that are constantly marketing.
Wow.
You go to LegalZoom and you do anything and you'll get 50 different things about, oh, you have software, let us file the copyright registration. They don't really file it. They're a typing service. They're essentially engaged. Some people think they're engaged in the unauthorized practice law. There's actually a trademark lawyer that decided to sue them, claiming that they're engaged in the unauthorized. Yeah, they decided to sue LegalZoom, saying they're engaged in the unauthorized practice of law, and that they're really,
well, I'm sure it is cutting into prosecution.
Well, it's
practice.
I mean, look at the trust lawyers that years ago there was a guy. He actually got sued by the State Bar of New York. I think he was actually a bold guy. He wrote a form book on how to do your own will and how to do your own trust with, this is before computers, with actually the ability to rip the forms out, like printed the forms. Oh, the lawyers got pissed at him because literally he had a bunch of blanks. He said, just put it in your typewriter or handwrite it. He was like, handwrite it. You can do a revocable trust in 5 minutes. Here's the form. So the State Bar of New York, this was like 1950s, right after World War II. The State Bar of New York went after him. You know what? They won until it got to the Court of Appeal, the highest court in New York. And the Court of Appeal was like, there's a First Amendment right, whatever he wants. What people do with it is their business. If they want to do it on their own, they can do it on their own. Just like a defendant can defend himself if he wants to in his own criminal trial. He can decide to do that, represent yourself. It's probably the stupidest thing in the world to do in a criminal case, but people do it. And if they want to do it, they can do it. And the Supreme Court and the Court of Appeal in New York was like, if people want to be their own lawyers, they can be their own lawyers. They're practicing on themselves. Now, if someone was using those forms to sell forms, that's a different deal, right? So if you think about it, so going back to what's not IP, I sent you 3 things that are worth looking at before we get to the Friday meeting. One is this case involving some plastic shoes in which the lawyer actually acknowledged that his client had no IP and filed in state court on some view of quantum meruit, which is like a shocking theory, like some theory that you copied my stuff and therefore you owe me money because it's only fair because I'm entitled to my work, like you copied my work. This case is so out of bounds in the sense that federal law preempts the view that something that's not copyrighted, not trademarked, not trade dress, not patented, not trade secret, and basically out there with no protection whatsoever, state law is effectively displaced. So you have no grounds to say, well, I'm going to just make up some tort under state law, like unfair competition or quantum meruit. So I sent that a while ago, like maybe a couple of weeks ago. I have to send it to Max and Nick as well because they probably were not on the list at the time. But basically, it's really kind of what I would say a bold move by someone who kind of feels like, hey, I designed these plastic shoes, and some big company, I want to say Target or some big company copied him.
I think it was Walmart, and there wasn't a patent on it, something like that.
Yeah, there's a case. Does anyone remember? Does anyone? Kim, do you remember? I sent this to Office at Computer Law a couple of weeks ago.
I'm gonna try and find the link. Zoom chat.
Yeah. Anyway, that handout is worth looking at. What's not IP is a good way to start and think about it. And it's a good way to think about how big the public domain is. Like the public domain is actually huge. If you think about the number of things we do that no one has any type of IP rights over. There's a huge number of things that are involved in the world that for which there's no rights at all. Yeah. So yeah, you found the article, enforcing IP without IP, right? Enforcing this guy decided to file a state court case in which he's going to, I guess, try to make some new law here, which is, whether Walmart could not essentially create these shoes. There's an article by Professor Dennis. I know Dennis Crouch for many years. He's a really smart guy. He teaches at a university, I think at the University of Missouri or somewhere in St. Louis, I think. So Kanye West helped design this, foam-like shoe. To me, it's what are those things that came out a number of years ago? What were they called? They were like boat
Crocs.
shoes. Yeah, Crocs, right? This is like
Yeah.
to me, everyone's like knocking off Crocs, and that's not even in the case because Crocs actually has a different look than this stuff, right? So on the left is the original, YZY foam shoes, right? And then there's Walmart on the right side, right? Walmart basically does this all the time. They find some company that can do it a lot cheaper, right? So the lawsuit alleges unfair competition and quantum merit based on California law. Defendants sold an imitation version, notwithstanding comments by consumers that should have been sufficient to alert Walmart that the imitation was somehow taking advantage of the goodwill of Kanye West and, Yeezy in marketing and profiting, right? So you have to ask yourself, and this is my second point, which is, and the tags are right on. You see the tags to the right, the popular tags, abstract idea, bunch of stuff on the right. It's exactly like, why didn't these guys file a design patent or file a copyright on the look of the shoe? Like, why didn't they actually decide to do something federally, to trademark it, to do something with it? Does anyone have a comment on that?
Probably didn't think they could.
Well, that's right, because to some degree, the question is this all functional, right? Is the whole design functional? Is it just like allowing air to go through a shoe, right? Because that's really what all these holes are about, right? Now, you could do a different number of holes and a different set of spots, and you can do different angles on the holes, right? You could put the holes, high heels have been around for a while with, some of them have like holes in the toe. What is that called when a high heel has a hole in the toe?
A peep toe.
Yeah, is that what it's called, a peep toe? Right?
Yeah.
I mean, they could have put like a peep toe in that probably would have changed it. But these guys under state law, and I keep wondering if like they're just like super smart lawyers, or maybe they're like not super smart. Like I'm trying to wonder, are they doing something? So sometimes showing the comments is interesting. So, there's 14 thoughts here. Sometimes you get some interesting commentary from people. One person says trade dress is not an evident path on the facts provided, nor is it sufficiently spelled out in the complaint. Blah, blah, blah. Different lawyers respond. It's sort of interesting to see what the opinions are. Some people just make jokes. Other people actually have substantive responses. Occasionally there's a decent response here. That's sort of interesting. At some point, someone will create some better way to see this stuff. But what do you think? Do you think this is like a serious attempt to have state law come in and say, wait a minute, you just can't do this? This is intellectual property in some form, because they're not using Kanye West's name. So it's not like they're committing trademark infringement.
Trade dress is a state claim.
Well, it's also federal under the Lanham Act. It can be federal.
Oh, that's true.
It can be state as well. But I think the line of argument goes like this, and it's not really spelled out in the complaint. Kanye West is famous. Kanye West designed these shoes. We've marketed to say Kanye West is this super creative shoe designer. Therefore, everyone now knows this is Kanye West's design. When you copied, you effectively copied Kanye West's name. Like, it's almost like Kanye West's face appears on that shoe. It doesn't. It's not there. And then maybe they would have been smart to maybe put his face on it in some way. But I think, Rita, you had a comment. What was your comment?
My comment was like with Converse, for example, there are different brands that would like take Converse and wouldn't call it Converse, but would be like the same style. So like, wouldn't that factor into that category? Or is it different because Kanye West designed these shoes?
Yeah, the argument is like Marilyn Monroe and other famous celebrities, Kanye West is at that level. And so the argument is once there's advertising that's done associating a star, a celebrity, with a product, then the product takes celebrity status. Like, that's really what they should just spell out in the complaint, because that could be another weird kind of state law tort that might theoretically be recognized, which is when you appropriate some celebrity in a wrongful way, you know, there's an argument that they have to be paid for their celebrity picture if they didn't give you consent. Now, there's all sorts of First Amendment issues wrapped up in that, but put the First Amendment to one side and ask yourself what's really going on here. I think what's going on is they're trying to define a new quasi-celebrity trade dress or quasi-celebrity dress tort, which is when a shoe is designed by a celebrity and worn by him and maybe his family of Kardashians. I don't know. Although I guess he's been stripped of the Kardashian connection because they're getting a divorce or they're separated or something. I don't keep up with this stuff, but I know
they're getting a divorce.
They're getting divorced, right? And then Kim failed the bar exam or failed the baby bar exam. So anyway,
yeah.
my point is that there's a state law case that a state law judge that knows nothing about intellectual property might well say, well, let's see what the jury has to say about this. You know, like, maybe I'm just going to allow this. And this would be like a perfect case for a writ, or almost a perfect case to try to get some sort of certified question. Is there a state law tort that's not preempted by federal trademark law, federal trade dress?
Stay tuned for part 2 of this episode of the Valley Current.